5, 4, 3, 2, 1. In the present case, we are concerned with criminal liability on account of dishonour of a cheque. It primarily falls on the drawer company and is extended to officers of the company. The normal rule in the cases involving criminal liability is against vicarious liability, that is, no one is to be held criminally liable for an act of another. This normal rule is, however, subject to exception on account of specific provision being made in the statutes extending liability to others. Section 141 of the Act is an instance of specific provision which, in case an offence under Section 138 is committed by a company, extends criminal liability for dishonour of a cheque to officers of the company. Section 141 contains conditions which have to be satisfied before the liability can be extended to officers of a company. Since the provision creates criminal liability, the conditions have to be strictly complied with. The conditions are intended to ensure that a person who is sought to be made vicariously liable for an offence of which the principal accused is the company had a role to play in relation to the incriminating act, and further that such a person should know what is attributed to him to make him liable. In other words, persons who had nothing to do with the matter need not be roped in. A company being a juristic person, all its deeds and functions are the result of acts of others. Therefore, officers of a company who are responsible for acts done in the name of the company are sought to be made personally liable for acts which result in criminal action being taken against the company. It makes every person who, at the time the offence was committed, was in charge of and was responsible to the company for the conduct of business of the company, as well as the company liable for the offence. The proviso to the subsection contains an escape route for persons who are able to prove that the offence was committed without their knowledge, or that they had exercised all due diligence to prevent commission of the offence. The position of a managing director or a joint managing director in a company may be different. These persons, as the designation of their office suggests, are in charge of a company and are responsible for the conduct of the business of the company. In order to escape liability, such persons may have to bring their case within the proviso to section 141(1), that is, they will have to prove that when the offence was committed they had no knowledge of the offence, or that they exercised all due diligence to prevent the commission of the offence. So far as the contention of the learned counsel for opposite party number 2 is concerned, it is well settled that only bald allegation against the accused that he is looking day-to-day affairs of the company is not sufficient. What are the roles being played for such business is required to be disclosed in the complaint petition, as has been held by the Honorable Supreme Court in S.K. Alag versus State of Uttar Pradesh and others, 2008 5 SCC 662. Paragraph 19 of the said judgment is quoted herein below. As admittedly drafts were drawn in the name of the company, even if the appellant was its managing director, he cannot be said to have committed an offence under section 406 of the Indian Penal Code. If and when a statute contemplates creation of such a legal fiction, it provides specifically therefore. In absence of any provision laid down under a statute, a director of a company or an employee cannot be held to be vicariously liable for any offence committed by the company itself. In view of the above facts, reasons, and analysis, the entire criminal proceeding in connection with C7 55/97, including the order taking cognizance dated 21/5/1997, pending in the court of the learned Chief Judicial Magistrate Chaibasa, is quashed. Accordingly, this petition is allowed and disposed of. Interim order, if any, granted by this court stands vacated. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.